Good morning, everyone, and welcome to our webcast this morning. My name is Patty Borsch. I'm one of the co-practice leaders of our absence management practice here at the Partners Group. Before we get started with the presentation, I want to do a couple of logistics so everybody on the line understands that we have a small live audience of employers in the room here in Bellevue with us, and they're just doing their very best to be very quiet so you can hear really well. But please do, in the chat box, let us know if you are having any interference being able to hear the webcast. Our presentation, we're excited that we have a tremendous response to this presentation. I think it's the largest response we've ever gotten for a webcast. We have over 220 individuals on the line with us and about 20 people in the room. So clearly this is a hot topic for folks today. So because of the large audience we have over the phone, I'm going to ask that you let us know what your questions are. You'll notice in the right-hand side of your screen, there's a box that you can type your questions in. We will be making sure that Jeff answers all your questions, and all registered participants will get a copy of the FAQs. Our live audience will be submitting questions, and we'll be answering what we can following Jeff's presentation here live. So you will be able to hear some common questions and answers, but just rest assured that you'll get all of your questions answered. We usually need about 7 days to get that back to you. We are recording today's webcast, and I know a number of you that responded indicated that team members might not be able to make it. So please know that we will be releasing a recording of the webcast as well as the FAQs that you can share with your colleagues if they couldn't make it. And I'm not sure who has the clicker, so let me pull that through here. Okay, so I'd like to just take, I'm going to just go through the agenda very quickly to let you know that I'm going to do a very brief overview of the Partners Group. Many of you in the audience are clients, so you know it, but many on the phone don't. So I'm going to try to keep that little commercial as brief as possible and talk a little bit about what we do in absence management, because that is the topic that is at hand today. We do many other things at the Partners Group, but the topic today is absence management. Our speaker will cover FMLA and ADA and all of those fun scenarios so that we can enjoy that deeply there. Very briefly, the Partners Group is the largest independent consulting firm in the Pacific Northwest. We have clients across the United States, but we are based in the Pacific Northwest. We have an office in Seattle, Portland, and Bend, Oregon. We're structured, and again, very high level in 4 key areas. Our employer services covers the work that we do for employers ranging from 40,000 employees all the way down to 2. It's primarily health and welfare consulting, as well as health and productivity, which is the absence management space we'll be talking about today, and population health. We have another division that does retirement products, both individual and employer. That's your traditional 401ks, 457, 403bs. We have a very large commercial division that works with all aspects of commercial insurance. And then our new emerging segment of our business is our data analytics. We have found that more and more our employers, especially our large self-funded employers, need concrete data and consulting. They need that in an integrated way, both from a health and productivity perspective. So we work through that division to make sure that we can help drive solutions through data. Rounding out the team with me today on our total absence management practice is Jean Shearer, who those of you in the room met earlier, and Brycey Rapoon. We lead the practice of the Partners Group. Together, we have over 80 years of experience. I know we don't look old enough to have that, but we do. But I'm not going to go through the list of projects that we've done for our clients, but we've had the opportunity to work from everything from a deep discovery and analysis to drive integrated solutions in the area of absence management. When we bucket our services for absence management, they go into really 3 core buckets. That's not to say that we don't do unique one-off projects, but usually it's around the topic we're going to talk about today, mitigating compliance risk. We look at total cost of absence on a direct and an indirect basis because it's important to understand, where the drivers of costs are so that we can drive ultimately solutions through that data. And why does this all matter? The top 3 things we hear from our employers around challenges, Jeff will be addressing a lot of those today, but it's the risk of non-compliance. And I think anybody that's had a knock on the door From the DOL or the EOC understand what the risks associated with that are, the cost of absenteeism, measuring that. These are the key challenges. And then how do we deploy our responsibilities in a consistent and a coordinated manner? And Jeff will be talking about that as well. Okay. My clicker, there we go. And so I'm really pleased to be able to introduce our speaker today, Jeff Nowak. Many of you know, with Frasnick Rallet, and I always mess that up, so he's helping me with that, is our speaker today. Jeff is widely recognized, as many of you know, as the nation's leader in FMLA and ADA expertise. He regularly consults his clients with compliance, conducting audits, training, and litigation. He is the author of one of the most widely recognized blogs, FMLA Insights. I don't know how many people here follow his blog. So there's a few
no hands went up.
There's a few other groupies in the room, Jeff. So he has a BA from Indiana University and graduated cum laude from Indiana School of Law. So please welcome Jeff.
Thanks, Patty. Thank you, everyone. Very few people actually voluntarily attend a session on difficult FMLA and ADA issues. So clearly, everyone here has a problem of some sort that they need help with. And thanks to everyone for attending, both live and through Webcast. For those of you attending on Webcast, I assure you there's no advantage being here live. First of all, I have a face made for webinar. And secondly, I assure you the live people are getting nothing more than water. So nothing special being live versus being online. Same broadcast, same session. What I've done in the presentation today is to identify four. I know there are many difficult issues when it comes to FMLA and ADA, but I've identified four really difficult issues that my clients deal with day in and day out. And then I've added one ADA issue, perhaps one of the most common questions that I get. Jeff, our employee is asking for their 37th extension of leave. Can we terminate now at this point? So we'll go through that exercise as well. My goal today in identifying what essentially are five areas, five common issues, is to provide you some practical insight. You can leave here today, leave the webcast today with several practical ideas to put in place, whether it's policy-driven, process, things that you can change if you're not doing them already now to help your compliance efforts, both in FMLA and ADA. So to go back to the agenda briefly, we're going to cover the four topics under FMLA, recognizing an employee's need for leave. What I find is that many compliance issues down the line in FMLA could have been resolved at the early stage, that first time the employee puts us on notice of the need for leave. Can we be doing a better job up front as employers recognizing the need for leave? Is it FMLA related? Is it not FMLA related? What do we do with the employee who doesn't want FMLA to apply? I need a leave of absence, but I don't want FMLA to apply to this absence. What do we do in those scenarios? The social media bust. Several times a month, I'm working with my clients who have found out, either through the grapevine or through social media, some really good evidence on their employee who is misusing FMLA. In fact, this past week, through social media, one of my clients found out that one of their employees is asked for FMLA leave at the very time he was to serve a 30-day sentence for DUI. So again, social media issues, somehow the employer is tipped off to the employee misusing leave. How do we handle those scenarios? A really important recent court decision was just issued just a couple of days ago in this area, further helping employers when it comes to misuse of FMLA leave. We'll talk about recertification. What is the DOL saying in terms of recertifying employees? When can you recertify? When should you recertify? And then finally, like I mentioned before, we'll talk about how we can put in place, again, practical steps to avoid a lengthy, kind of indefinite, never-ending leave of absence after FMLA is ended. What are some steps that we can put in place? And my apologies for going back through the slides here. So let's jump in. The first scenario, recognizing FMLA leave. So you have an employee, Susie. She's one of your clerks. She has 2 parents that she has to care for on a fairly regular basis. And recently, you've overheard her talking about certain things with respect to her parents. The idea that she may need time off to care for Dad because he's undergoing chemo. Casual conversations about caring for aging parents, again, just kind of a general nature. You also know that she generally can't work overtime because she's often taking Mom and Dad to various things, including doctor's appointments. So here's the pattern most recently that you're running into. On some occasions, Susie leaves a voicemail indicating that she has to take Dad to a doctor's appointment. And you may have some kind of call-in system, whatever you have set up. Perhaps it's voicemail, perhaps it's a call to the supervisor, whatever it might be, but that's her excuse on some occasions. On others, she texts her manager, letting the manager know that Dad is not well today. She's going to take care of him, look after him on that occasion. And still on other occasions, she's telling you she's dealing with her own stress because of what she has to provide. Sometimes she reports them late, so let's assume that you've got some kind of call-in policy requiring employees to call in a certain amount of the time ahead. She calls in late at times. And now Susie's supervisor, of course, wants to discipline, wants to be, oftentimes we run into that supervisor who wants Susie gone, right? The supervisor has had enough. What can we do in response? So we have a lot of nuggets of information here. There is a misconception, particularly among supervisors, who may not know a whole lot about FMLA or ADA, common misconception that it's hands-off when it comes to medical information. That when the employee calls in and says, my dad's not feeling well today, that we can't inquire further. We can't ask any further questions. We take that as it is, and we may or may not write it down somewhere, and then we move on. That's a problem. That's a compliance problem for us. The FMLA allows us, in fact, it demands of us, if we have any question about whether this may or may not be FMLA, to inquire further. If we don't inquire further, we potentially suffer the consequences if we mistag it as a non-FMLA unexcused absence versus one that very well could be covered by the FMLA. So we see here in the past slide, she could have put us on notice of the need for FMLA leave on a number of these instances, right? Taking Mom or Dad to a doctor's appointment, looking after Dad for the day, can't come to work because he's not well. She's tipping you off to her own issues, potentially covered by FMLA. So you have a decision to make in situations like these, and I encourage you from an operational standpoint to decide what path you're taking. Because I recognize for some large employers where you have oodles of employees, your response to me here is, Jeff, we can't simply call every employee back when they tell us we're taking Dad to an appointment. And I get that. I understand that. If you're not using TPAs and you're handling everything yourself, I understand that. You don't have the benefit of returning every phone call. So then you have a decision to make. Either you have a more hands-off approach and you're looking for perhaps more than what you have here, perhaps a longer absence. So you're not tagging those one-day absences. That's a decision that you have to make operationally. It's not ideal, and it is potentially fraught with problems from an FMLA standpoint. But if you are going to go down that route and you don't have the ability, or if you just don't simply have the resources to be returning phone calls and calling back and inquiring, then you need to decide at the back end, what are you going to do about all these absences? So when the supervisor comes into your office and says, we need to do something about this employee because she's gone too long, we need to delve further into what every one of those absences were. Because if you've not properly gone down the FMLA road on these absences, and instead you've put them in another column, an unexcused absence of some sort, you're creating liability for yourself down the road. So if you suspend this employee, if you terminate her, she's got a pretty decent FMLA case, likely. Taking Dad to the appointment, caring for him on a particular occasion for whatever period of time, an hour or a full day. Those are, from an information standpoint under ADA, that's enough to put the employer on notice that this employee needs leave. So we really need to, on the back end, go through those absences with the supervisor and be satisfied ourselves that these could not have been covered by FMLA. If they could have been covered by FMLA, then we have some work to do. And it does create an administrative mess for us, because now we're going back sometimes several months to study an absence that no one really has a fresh memory of why she needed leave on that particular occasion. So the best approach that I can share with you, the most compliant approach, is to arm your person answering the phone that morning, answering the call-ins, or that you have someone that can call back the employee to ask these questions that I've included here on the slide. You don't need to use all of them. You may use some of them. And I'm not suggesting that you use it for every person who calls in. If Jane Doe calls in and says, I'm just not feeling well today, I'm not coming in, that's not a callback that we need to make. That's a sick day. Not putting us on notice of FMLA leave. But for sharing information of the kind here, that's enough to put us on notice that FMLA might be in play. And so we may want to ask, what is the caring for function you're providing? How are you caring for mom and dad? Get some basic medical facts behind what's going on with mom and dad. We have a right to know that. We as the employer have a right to know why our employee can't be at work today. And in these cases where she's alluding to caring for her dad, we have a right to know what care is she providing? What is he dealing with? Is he seeing a doctor for these? And that's different than a dental appointment. I'm taking Dad to the dentist today. That's not FMLA. But if I'm taking Dad as a result of his cancer, his chemo, now we're in FMLA land. So I encourage you to use these questions and arm your person answering the call or returning the phone call to ask these kinds of questions so that you're in the best position to know, is this an FMLA absence? Use your call-in policies to your advantage. So again, a practical tip to take with you today. Go back and study your call-in policies. What do they say? Do they use kind of basic general language? The employee should call in as soon as possible to report their absence. Get rid of that kind of policy. Have a policy that is specific in at least two ways. One, some kind of time period, if you can. Now, I get that, particularly in many white-collar environments, we don't want to set some kind of time limit for our employees. If we're a union facility, on the other hand, or it's time sensitive, we need to know from a staffing standpoint, then of course we want to have those time requirements. But number one, if you can put in some kind of time requirement, you are to call an hour before your shift. And secondly, identify an actual person they are to call. If it's supervisor, that's fine. HR, call-in line, whatever it might be. Identify a person that they are to call. That's going to be critical for you if you've got to defend an FMLA case down the road. And that's frankly a great situation to be in, particularly where you don't keep track of every phone call that's made and you don't make that call back. If you have a very strict, a very specific policy, call-in policy, that goes a long way to helping you stay compliant. Because what the regulations say is that you can hold every employee to that call-in policy unless they can identify an unusual circumstance, an emergency, prohibiting them from following your call-in policy. So many of my clients have been benefited from this change in the regulation from several years back. So make sure that your policies are specific enough. Also, if you use a TPA by chance, there are plenty of court cases that support your right to have the employee call in to two different places. So you call into HR and you also call into the TPA if you want to request FMLA leave. That too has been effective. So if you want them to call into two spots, the courts support your right to do that. Now, unionized environments, I know there's some school districts attending today. You may very well get some pushback from your unions, but I think you can rely typically on your management rights clause in your contracts to require your employees to call in to a specific spot or to two different places. Keep in mind too, for those of you, and I include this slide, for those of you who have an employee who logs in phone calls, and one of my clients learned this the hard way this past year. So take the case of Jamie, who works for University of Pittsburgh, terrible employee. It's always the terrible employees that trip us up, isn't it? So those with the checkered attendance record, they're not good employees, and then they get us on some absence that's FMLA related, and it's the last straw for the supervisor, and we end up in some kind of FMLA liability, like the employer here. So the employee calls in to the supervisor, Jamie calls into the supervisor and indicates to the supervisor, I'm currently in the ER. My mother's been brought into the hospital by ambulance. I'm unable to work today. Well, for that supervisor, for the employer here, that was the last straw. Again, terrible attendance record. She's calling in again. And the supervisor writes into the log, sick mom. Doesn't tip anyone off to the fact that she's also, by the way, in the ER with the sick mom. That's a problem. And it was a problem for actually this past year for one of my clients, who the plaintiff in this particular FMLA case said, on this occasion, which proved to be the last straw for my client, on this occasion I called in and I said my back was acting up, I wasn't coming in. And in an email that the supervisor sent to her boss said, Cindy is sick today. That's a problem, because the supervisor gets that email, sees Cindy is sick today, and decides, okay, this is it. This is the last absence. I'm not taking anymore. She was terminated that day. Well, in the court case now, we're dealing with a different story, right? So it's really important to train your managers. Whatever they hear on the voicemail or on the phone needs to end up in the log or the email that's communicated to the person in charge. That creates a compliance issue for us. Keep in mind, too, that the texting, in this case, she called the supervisor. There are other cases that deal with texting. Again, you can have, and you should have, in your policies, some language about texting. Make it, put it out there. Make it clear, and decide what you want to do. Okay? And you can very well say, texting is not good enough. Do not text your manager, your supervisor, whoever, to report your absence. That's not acceptable under our policy. If you're going to have that policy, follow it. Okay? What I often find is that kind of policy, it's a no texting policy, but then when I'm investigating the FMLA lawsuit that we're involved in, I find out that the manager accepts text messages from their employees when they're calling in. That's a compliance problem for us. Because what the court is going to say in our situation is that you may have a policy that says no texting, but you have a practice of allowing your employees to text. And so we're going to consider texting to be sufficient notice to put the employer on notice of the need for FMLA leave. So critical compliance issue here, recognizing that request up front. Can't emphasize this enough because I just see it play out way too often for my own clients, that they're not doing enough up front to figure out the FMLA situation and using the tools available to them to discipline where appropriate. So let's take the scenario where the employee needs leave but doesn't want to take leave. And And I use, as I often do, I use the Escriba decision which is a Ninth Circuit decision from a couple of years back that really kind of brought this kind of issue to the forefront. She goes to her supervisor, and there was some kind of language barrier, clearly, and that complicated things here, but she tells her supervisor that her father is no good, that needs to take vacation, essentially go and visit him in another country. Supervisor approves 2 weeks of vacation. She comes back to the supervisor later and she says, can I have 1 or 2 weeks free for me? Supervisor later confirms that Maria doesn't want to take any more than 2 weeks total vacation to go and visit with her father and care for her father. Then Maria later goes to the top dog, to the plant superintendent, and says, I'm going to Guatemala, my dad's very ill, I'm only going with 2 weeks, but can you do me a favor and give me 1 or 2 more weeks of leave? And the superintendent, of course, says, no, not allowed. Maria, by all accounts, knows exactly how she's to request FMLA because she's taken FMLA leave 15 previous times. She was an FMLA aficionado. She knew the FMLA better than I knew the FMLA. She's that adept at it. And then, as the story goes, she stays in Guatemala well past the 2-week period that she initially said, and she is terminated as a result. No call, no show. She doesn't come back to work. So she files an FMLA lawsuit, and of course, her attorney argues, as he or she should have, well, Maria, when she talked to the plant superintendent, indicated to him that she may need more than 2 weeks, so she put the employer on notice of the need for leave. So this should be covered by the FMLA. And so the court here grappled with this issue. Can an employee decline FMLA? And the court actually found for the employer here and decided that yes, she declined FMLA leave, and therefore part of her leave was unprotected, and therefore the employer could terminate her. But what it created was a problem for us in the future, where what the court says, there could be occasions when the employee declines FMLA leave. And that's a problem for us as employers, because we want a bright line rule. We don't want any ambiguity here. If FMLA applies, we want it to apply. And we don't want the employee to have a right in this process. It's covered by the law, and we should follow the law, and that's it. So what I've encouraged my clients to do, what many other attorneys, if you don't believe me, encourage their clients to do, is to ignore this decision. Just simply put it to the side. The DOL, I can tell you, has put this decision to the side. The DOL doesn't follow this decision. Because what the DOL tells us is that if FMLA applies, employers have an obligation to designate it as FMLA. That the employee doesn't have a say in the matter. So what do we tell our employees, to that employee that says, I need leave for whatever reason, we can all agree it's covered by FMLA, but I don't want FMLA to apply. And I'm not sure why they want that. Maybe they're just hoarding FMLA take later in the year. I've never understood this. But my response to that question is twofold. One, explain to them our obligation as employers. As the employer, where we're in an FMLA situation and we know that this absence is covered by FMLA, that we have an obligation under the law to designate it as FMLA. We don't have a choice in the matter, and nor do you as the employee. So in that sense, it's as simple as that. And secondly, remind them that they want FMLA to apply if FMLA does indeed apply, because it's different than any other kind of leave in that it protects their job. And they want job-protected leave if it actually is covered by the FMLA. So, that's my reaction to this situation. And I know that my clients deal with this a lot. And the common question, to maybe predict one of your questions, is what do we do with that employee who, like Maria or similar to what I've posed to you. I need FMLA leave, but I don't want FMLA leave to be exhausted. What if they thumb their nose at us and say, okay, well, I'm not going to turn in medical certification. So you can give me all your paperwork that you want, but I'm not going to turn it in, and then you're not going to be able to designate it as FMLA leave because you don't have a certification. Well, we have a decision to make as the employer. Keep in mind that under the regs, we don't have to have a certification to designate FMLA leave. So if we are certain, and we really need to be certain, that FMLA applies, so if it's a serious illness, surgery, if you know that they are dealing with migraine headaches, it's been reported before, and you have certification in the past, so you have some certainty that these occasions are covered by FMLA, then you're in a pretty safe area to go ahead and still designate that time as FMLA leave. And that's a pretty defensible position to be in. On the other hand, if they don't turn in certification, you can also deny FMLA leave for that instance. Now, you may have policies that allow an employee still to use their accrued paid leave in those instances, and there's not a whole lot you can do about that, and I get that. And that is a problem for us, that they may not be protected under FMLA, but they may be able to then use their accrued paid leave, and they're able to get out of that loophole. But we do have a decision to make, and if we can, wherever we can properly designate FMLA leave, I encourage my clients to do that. And again, I don't think we mentioned this earlier, but we'll take questions at the end of our program, right? And I'm happy to stay for whatever length of time to make sure that the questions are answered. So let's talk about social media. Because, again, as I mentioned before, this is an increasing issue for my clients, and I've used this example before, so I apologize if you've seen this scenario before, but it really does kind of encapsulate so many different situations that I see with my clients. Gia is one of your employees. She needs leave to care for mom in Mexico. She needs a continuous period of leave. And let's assume that she provides certification, so all the paperwork is in good shape. Gia goes off on leave, and now one of her coworkers, who probably has to pick up the slack for Gia while she's out, happens to be a Facebook friend of Gia, and the long and short of it is that her Facebook homepage is filled with photos of Gia, not in Mexico, but in Germany, somewhere else, somewhere other than Mexico. And the photo looks something like this, you see. And she provides this information to you, Molly does. And now we have a situation where, based on what we're seeing from our employee, Molly, we've got a pretty good idea that our employee, Gia, is abusing FMLA. She should be in Mexico. It looks as though she's somewhere else based on the location of her Facebook post, et cetera, et cetera. What do we do in this kind of situation? Courts are increasingly supporting employers' defense when they can establish that they have an honest belief that the employee was abusing FMLA. It's a fact-intensive kind of review by a court, but they do support this defense, and it's increasingly common in FMLA cases. So how do we apply this practically to our day-to-day situations when this kind of situation arises? The long and short of it is that the employers win these cases in the court system if they've conducted a full, complete investigation into the facts. Employers lose, on the other hand, when there is a knee-jerk reaction. So my client situation last week, if my client finds out and has really good evidence that this person is in jail for 30 days at the very time that they're requesting FMLA leave, knee-jerk reaction is to say, off with his head, right? I have it here right in front of me. He's terminated. Employers lose those court cases because they've not conducted any kind of investigation into the facts. So learn the facts, know the facts from Molly, who's reported that to you. Be mindful of state law in these scenarios. Some states across the country have social media laws that prohibit you from accessing your employees' social media account. You can't ask them certainly for the password. Many states you can't even look over their shoulder while they're showing you their own Facebook page. So if you're in a state that has those strict kind of laws, make sure that you know what your parameters are, and then act accordingly. So at a minimum, in those states that have those protections for employees, ask them, or let them know, I can't access, I can't look at your account, but I will take whatever you voluntarily want to share with me. If you want to print stuff out and share it with me, I would appreciate that, but I cannot require it at all for you to do that. So be mindful of that, but learn the facts. Make sure that you are fully armed with the facts before Gia comes back and then you meet with her. But you want to confront Gia with what you've learned. And first, as I've indicated here on the slide, and you can use this as your roadmap down the road, you want to confirm that she was in Mexico and that she was caring for mom. Lock her into that story. Then you can go down the road of reminding her that you take that she's aware of your FMLA policy. It's in the handbook or wherever you have it. So she acknowledges that she's familiar with that FMLA policy. If you have a really solid, strong FMLA policy, you've got a good section in that policy about abusing FMLA leave. That's a violation of your company policy to misuse FMLA leave. If it's not in your policy, make sure to put it in your policy, because you can rely on that in these situations. And then you're able to confront her with the facts. That you have evidence that indicates she was not in Mexico, but rather she was elsewhere. You care to explain to me what you were doing or why that information would have come to me. And if she doesn't fess up, then you at least have now, you have the photo of her and her friends, right, at the local bar or Pop World, whatever it was called, that you can confront her with. On one hand, she may fess up to you, and that's great. On the other hand, if she continues to deny, you have a reasonable belief, of course, that she was misusing leave, and you can then take disciplinary action, whether that's, and that's what you have to decide, suspension, termination, whatever it might be, under your own personnel policies. I'm asked from time to time, what about the timing of the meeting? Do we call her in right away, or do we let her finish her leave and then talk to her when she comes back? You know, that too is fact-driven. I'm inclined to just let her do what she's going to do, and let's talk to her when she comes back. That's my typical approach. Then you've given her all the leave that she's requested, right? So you avoid any kind of FMLA interference claim. She can't file any interference claim against you because she's used all the leave that she asked for. And secondly, you let the facts wind themselves out. You may learn more, but then you can confront her with it after the fact, after it's happened. So that's my suggestion in terms of handling social media. What about recertification? So here's an awfully common scenario that I deal with my clients. Fred is one of your employees, and he suffers from IBS, which is not uncommon, right? Very common. I get this diagnosis a lot from a lot of my clients, and they're particularly when it comes to intermittent leave. Certification indicates that they are going to be absent or have flare-ups twice a month, lasting 1 day each. So here's your pattern with Fred. Over the past 3 months, he's absent 3 times, then 2 times, then 3 times. He's also absent almost always on Mondays and Fridays. Isn't that the case? Or a holiday, or something else that's suspicious. Can we, in this scenario, seek recertification? Can we ask for more information? what does that recert look like? How do you approach it? So in terms of the general rule on recertification, we can't, as a general matter, we typically cannot ask for recertification more often than every 30 days. But we have to look at what the duration says on the certification form. The duration says Johnny's got headaches, or Fred has IBS. It's a lifetime condition. We get that a lot, right? Or it's some lengthy duration. Typically, we cannot seek recertification until that duration has expired. So it's 3 months, 4 months, 5 months. We can't seek recertification until that duration has ended. However, we can, as a rule, we can require recertification in any case every 6 months. So for those lifetime conditions, we can recertify in 6 months, so long as it comes in conjunction with an absence. And I've seen that too, where some of my clients automatically recertify at month 6. That's a no-no. It has to be in conjunction with an absence. It can't be an automatic recert. We have to have an absence that's occurred for that condition after 6 months, and then we can seek recertification. We can also seek recertification really as often as we'd like if certain limited situations apply. There's an extension of leave, so let's say it's a short duration, that's expired and now they're seeking more leave. We can seek recert in that situation. The key point here, the key exception, is if circumstances have changed substantially, significantly. Keep in mind that word, and we'll come back to it in a second. If you get information that casts doubt on the situation, that too is subject to recertification. So again, your social media scenario where you uncover facts from an employee that suggests misuse of FMLA leave, you can certainly recertify in those situations as well. So do we have a significant change in frequency? Keep in mind, last 3 months, 3 times, 2 times, then 3 times. The Department of Labor emphasizes that the frequency and duration on a medical certification is an estimate of what the employee needs. And to some extent, I begrudgingly agree with the DOL on this point. A physician who is a specialist in the neurology area can only estimate how often their patient is going to have a migraine headache in an average month. Is it 2 times, 3 times, 4 times? It is an estimate. And so what DOL says is, and this is an issue, it's an issue that DOL is focusing on in many of their offices across the country. Employers who seek recertification too soon, too quickly, when frequency is exceeded. They take the position, the agency takes the position that it has to be something more than 1 time over frequency. So keep that in mind. For Fred here, at worst, he went 1 over the frequency over the past several months. DOL is certainly going to take the position that's not a significant enough change for you to recertify. But what about the pattern that we're seeing here? The regulations allow employers a really critical tool here that frankly we don't use enough. They allow us in this scenario, Monday, Friday absences around a holiday. Let's say the employee has asked you for a vacation day. You deny that vacation day for a legitimate reason. Let's say that they're the 3rd person to ask. You can't let anyone be off on that day. And lo and behold, what do? They call in sick on that day that they asked for a vacation day. That's suspicious. That too can be a pattern. All of those scenarios we can challenge through recertification. And not only recertification, but we can send a note to the doctor, again, through the employee. We can't send notes directly to the physician. But we can send a letter to our employee directing that employee to take the letter to their physician and have the physician answer your questions. And in that letter, what I do is I lay it out for the doctor. I explain the pattern that we're seeing. And I tell the doctor flat out, we are concerned that our employee is not using this for an appropriate reason. We need your help. We need your opinion. Please confirm for us whether this condition, whether this need for leave or this pattern is consistent with the employee's serious health condition. And is it necessary? So now what are you most often going to get back from the doctor? You're going to get a rubber stamp, right? Of course, my patient needs leave on these occasions, and it may very well be that they need leave on Mondays and Fridays. And we may get that often enough. Some of you might tell me, yes, 98% of the time it's going to be a rubber stamp, Jeff. So why do we go through this song and dance? For a couple of reasons. One, we're putting our employee on notice that we're on to that we see this pattern and we have a problem with it. And I don't have any problem too with you sitting down and talking to your employee about the pattern. This is what we're seeing here. Can you help us understand it? Because maybe there's a legitimate reason for Mondays and Fridays, particularly where there's some kind of medical treatment involved. Maybe they take those days off as a recovery period. So let's not be too quick to jump on them for that kind of pattern. But it's also an opportunity to sit down with them and to let them know face-to-face about your concerns, about the pattern that you're seeing. So it shows them that you're onto them. And secondly, it encourages conversations between doctor and patient. And I've given presentations before to physicians, to doctors. When they insist, they tell me that this kind of stuff, this kind of letter, causes them to have a conversation with their patient. So it is happening out there, where doctors are telling their patients, look, I'm seeing what's in this letter, and I'll rubber stamp you this time, but I'm not going to do it again. And they're also telling their patients, look, watch out. They're clearly onto you. Something's going on here, so mind yourself. So those conversations are going on, and perhaps that's what you want as the employer. Maybe that's good enough for you to, over time, curb abuse, curb FMLA abuse. So I say use it. Not enough employers are. But keep in mind, again, I can't emphasize enough, you can't communicate directly with the physician. You can't do that without your employee's permission. FMLA has very specific rules on communicating with physicians. So be mindful of that. You provide it to your employee. You can require them to give it to their doctor. Give them a recertification form to go along with it, and give them the 15 days as part of the recertification process to have that, to return that to you. And you can even require in the doctor's response, you can ask the physician to confirm that they have reviewed the letter, so that you know that they're not getting the employee side of the story. Maybe the employee didn't share that letter with them, but rather kind of paraphrased what's in that letter. So you can ask the doctor, please confirm in your correspondence to us that you have reviewed our letter dated whatever date. So keep that in mind too. Finally, what do we do when FMLA is done, and now we have an employee who still cannot return to work? And really there's two scenarios that pop up. One, they still need leave, so they might be on a continuous leave of absence. This often pops up in workers' comp situations. Extended period of time, and 12 weeks end, and they still can't come back to work, so they need additional time off of a continuous nature. The other scenario that's common for my clients is the employee who returns to work, but then is sporadically absent thereafter. So they've exhausted FMLA, and now we're in ADA land, but they're absent once a week for this particular condition. What do we do in these scenarios? And what I'm going to do is lay out for you a typical scenario that I run into, but with an approach that puts you in the best position possible to, if you need to terminate your employee no later than 2 to 3 months after FMLA ends, so that you are, by the 3rd request for an extension of leave, you're terminating employment, or at least you have the option to terminate employment. So here's the scenario. So Susie is transferred into an assistant director position this previous year. She has neck pain, blurred vision, dizziness. She's later diagnosed with spinal cord compression. And this is an actual court case, and I'll explain the court case in a second because I think it's really instructive to us as employers. She's diagnosed with spinal cord compression, very painful condition. You provide accommodations, time off, change of schedule, try to work with her to help her stay at work. The condition gets worse to the point where she needs to go out on leave, FMLA covered. But you don't hear from Susie during that FMLA leave. That's problem number one, and we'll come back to that in a second. Now you're coming up on the 10th week of FMLA, so you see the end of FMLA there. It's coming soon. What do you do in this scenario? What are your obligations as the employer? What about the employee? Does the employee have any obligations? This is where the FMLA, particularly the regulations, offer us absolutely no help. We are in no man's land when it comes to this scenario. There's no requirements under the regulations for you to communicate with your employee. After you provide that designation notice, there's no obligation under the regs to communicate again. And conversely, there's no obligation for the employee to stay in touch with you. Now you can require it, and as some of you may know, in the designation notice, you can set a period of time for that employee to check in with you, but there's nothing otherwise requiring them to stay in contact with you. So this really is an opportunity for employers to lose track of their employees, and I encourage you to avoid that. Have some kind of regular check-in for your employees and do what you can to apply that across the board. So even on that continuous absence, in the designation notice you're saying, we're asking you to check in every month, once every 4 weeks while you're out on leave. Every week might be a little too much, particularly for those of you who are larger employers. But set some kind of interval where you're requiring them to check in. And if they don't check in, do it yourself. Be proactive. Stay in touch with them. Don't lose track of them for 10 weeks. It allows you to assess the seriousness of their condition. Are there accommodations that you can offer to help them get back to work sooner than 12 weeks of FMLA leave? It also helps you predict the end. If you're in regular contact with them, then you have a much better idea as to whether this employee is coming back at the end of 12 weeks. So I know that many of you, particularly live, cannot read this, but you can use this for your own purpose after you leave here today. I have copied and pasted the typical letter that I use at about week 10 of FMLA, of a continuous leave of absence. The employee is out. At about week 10, I send them this letter reminding them that FMLA is about to come to an end, that we anticipate that they'll be returning to work at the end of FMLA leave. If they can't, they are to call you ASAP, call you immediately. And then I include some ADA-friendly language, inviting them to talk to us about any assistance they might need to return to work. And I call this my Stevie Wonder letter. I just called to say I love you. I just called to say how much I care. We're showing our employee that we care about them. We're also showing the jury down the road that we care for our employee. Many employers don't use this kind of communication, and then they lose track of them. So FMLA comes and goes. They remain on leave for whatever reason, and we've lost track of them. This is an opportunity to stay compliant, first of all, to help identify opportunities to help our employee return to work. It also shows that we care. we're saying here in black and white to our employees, something that we can later use down the road in conversations with them, or if we've got to defend ourselves in litigation, we're showing that, hey, we reached out to our employee and we invited her to identify any kind of accommodations that might help her return to work, and she didn't respond to us, or here was her response. It puts us in the best position possible in a number of ways. So let's say that you send that letter out to Susie. She gets it and she calls you back before FMLA ends, and that's the best case scenario for us, that she gets the letter and she then calls us right away. If we don't hear from her, if we can, again, if our operations allow, reach out to her and figure out, is she coming back? Is she set to return at the end of FMLA? And if not, then let's work that out. Let's figure out what information we need to perhaps provide additional leave. But be proactive in this area so that you know what to do, what your plan is for the end of FMLA. She tells you in this conversation she needs another 4 weeks off beyond FMLA. So 12 weeks is going to be up. I'm going to need another 4 weeks. Recovering from surgery, she tells you, I know I'm a burden to you, but I'm still in pain. I miss you guys. That's what she tells you. 4 weeks, her doctor's going to review her status, and she'll know whether she can return at that point. So how do we respond in this situation? So you've sent her the letter at week 10. She's asking you for more leave. Be proactive. Stay on top of this. This is part of my plan for you. Put yourself in the best position possible in that second to third month beyond FMLA. Find out from the employee, send a letter that includes these kinds of, that includes all the bullet points here and the questions. Again, like I said earlier, you have a right to know why your employee can't be at work. So here, we want to know basic medical facts. What are you dealing with? And you may already know what you're dealing with in terms of a medical condition, so you don't need to delve much further into the medical condition. But we do want to know, how does it affect their ability to do their job? We want to know that. And some doctors will say it affects the job completely. They can't do any of their essential job duties. And that's fine, but ask the question. Maybe the doctor will offer something to us in terms of their limitations that will then in turn give us an idea, okay, maybe we provide this accommodation, then it helps Susie get back to work. So ask that question. Ask the doctor to identify any kind of accommodations that might help the employee return to work. But also be direct with the doctor. When can we expect this employee to return to work? And is any additional leave that might be provided, is that going to help them return to work? And what I ask for is, again, you send it through your employee, you send it to the employee, take it to your doctor. We need a report back from your doctor with a response to these questions. And I typically ask for it within 7 to 10 days, calendar days, after I've sent it out. So again, quick turnaround, but it's reasonable enough for the employee to take it to their physician and get it completed and returned to us. And typically in this scenario, I recommend approving the leave. I don't almost never want to be in a situation where FMLA ends and we are terminating employment immediately thereafter. I think that's problematic for employers, and I run into that often enough with my dear clients who think that when FMLA ends, then job protection ends, that we can fill the job or we can terminate. That's not the case. If you have a practice where you automatically fill the job after 12 weeks, please get rid of that practice. That's not compliant with the ADA. What the ADA tells us is that we are to keep that, technically speaking, we are to keep that position open for the employee while you're providing additional leave under the ADA. You can temporarily fill that role, but they are entitled to return to that position. So it's more strict than the FMLA. They're entitled to return to that position when they're ready to return to work. So you tell her, okay, we'll give you 4 weeks, but you need a document confirming that she can return to work without restrictions. What's the problem there? Okay, without restrictions. Take that language out of your letters as well. EEOC takes a very hard line on that kind of language at EEOC offices across the country. Because the EEOC takes the position that if you require your employee to come back 100% healed or without restrictions, that you are not engaging properly in the interactive process, that you're not considering facts available to that person's situation that, that requires you to provide an accommodation. Okay? So we can't insist upon the employee coming back to work without restrictions. After the appointment, 4 weeks later, Susie avoids you. I know that never happens in your workplaces, but here it does. So you give her an extra week before you bug her, but then you finally call her. Now you're 5 weeks out after FMLA. She requests another 4 weeks from you, still recovering. Physician wants to meet with her at that point, and she tells you the doc thinks I'm going to be ready to return to work. So what do you do at this point now? So one thing that I encourage you to do, first let's back up a second. After you've provided that first 4 weeks of leave, so FMLA has ended and you say, all right, Susie, you can take 4 more weeks. The first thing that you do after you give that first 4 weeks, that first initial period, you grant that as essentially as an accommodation, go back to your managers, supervisors, whoever works with Susie, and engage them in a discussion about how Susie's absence is affecting their operations. If you haven't done that already, do it immediately in that initial time period. You don't need to tell her that on the first extension, but find out how it's impacting operations, because you want to use that information to have a conversation with Susie now the second time, or she's asking for the second extension. What's an undue hardship on your operations? What are the problems that you can identify? Are you using temp workers? Are you incurring a lot of overtime costs because you have to cover for Susie while she's out? Does quality suffer? For those of you that sell widgets of whatever kind, can you show lost sales? Are sales affected by her absence? Customer service has decreased. You can show that there's been an impact on customer service. Are you pushing projects off? A project that you wanted to tackle this month has to get pushed off because Susie is absent. Are other managers, are other staff having to cover for Susie while she's out, and therefore they can't do their own job 100% of the time? Stress, overburden, coworkers, morale. These last 2 bullet points are not all that important, at least the EEOC, they're not all that important. So these first 6 bullet points are critical pieces that we can start putting together to have that discussion with Susie. Because the second extension, what I'm doing is not automatically granting it. I've now, while she's been out that first 4 weeks, I'm trying to identify how it's impacting operations, number one. When she asks for that second request, we also have the option of, again, reaching out to the physician and learning why does she need more time? This might be a lot of work to some of you. It might be a lot to add to your administrative side. So I recognize you all can't do that. But if you can do one or the other, certainly focus on how it's impacting your operations. If you have the opportunity, send the letter. How much additional leave is needed? Why is it needed? Why was your estimate wrong last month? Ask the doctor that. And again, ask for that report back. The EEOC tells us that we can ask those and other kinds of questions to determine how the absence is affecting our operations, how we can show undue hardship. Keep in mind, too, that we never have to provide leave where the doctor hasn't identified a reasonable estimate for return. So last week for a client, the employee has been out for 2 months, now just returned to us a doctor's note that said needs to be out until at least July of 2017. So that's another 6 months down the road. And the doctor has offered no reasonable basis for believing that the employee is going to be back in July of 2017. That is that's an indefinite leave scenario. And what the EEOC tells us is you never have to stand for that. That's not a request for an accommodation that you need to comply with. So we are, in the scenario I just outlined for you, we're in a pretty safe zone to either fill that position or terminate that employee from her employment. So before I go further and explain this particular court case that Susie is based on, just to, again to reiterate, when I typically grant that first request after I've gotten information from the employee. When the second request is made, again, by then I will have already discussed with my supervisors how is the absence affecting operations, because then I tell Susie that in the response to the second request for that second set of second extension, so the additional 4 weeks. I'm telling her in the letter that I'm providing her, we'll go ahead and grant an additional 4 weeks of leave. But it's important for us to tell you this. And that's where you lay out in that letter how our absence is affecting your operations. That is, it's like kryptonite to the EEOC. So that kind of letter, that's what EEOC wants to see. In talking with EEOC attorneys, in going up against EEOC attorneys, I can tell you that if we can show in our communications that we've engaged that employee in a continual dialogue with them about their medical condition and what they might need to return to work, and if we tell them very specifically in a letter how the absence is affecting operations, EEOC almost always goes away. They have no interest in our case. Because from their standpoint, from the agency standpoint, we are being compliant under the ADA. So they're not in almost any situation where we can show that constant communication and where we can show that we've identified how that absence is affecting our operations. The EEOC is likely going to have no interest in that case. And that's helpful to us. We get the EEOC off our back if this ends up in litigation. But I'm identifying in that second letter how it's affecting our operations, and I'm telling Susie flat out, it'll be very difficult for us to provide any additional leave to you at this point. Then that gives you the perfect opportunity then, if she requests yet another extension, for you to say, at this point, we can no longer provide you leave and fill the position or terminate employment. I held a webinar. Some of you may have attended a year ago, about a year ago, 6 months ago, with one of the EEOC commissioners, Commissioner Feldblum. And I put this exact scenario to her. And although she couldn't endorse it on behalf of the EEOC, she suggested that that is a fairly compliant approach, the approach that I just outlined for you here. That at the end of that second request for leave, when the employee then asks for the third extension request, that you are in a really good position to terminate employment and to be compliant with the ADA. So that's my suggestion. This case, Susie's case, is based off of a case called Henry versus United Bank, and I think it's, if you have a chance, for those of you nerds out there that like to read court cases, which may be zero in the audience, this is a really good case in that the court takes a very straightforward, non-legalistic kind of opinion, but it really lays out in common sense terms what an employer should do when an employee is on an extended leave of absence, and what it can show, what it should be doing to show the impact on the operation. So the court in this case was particularly persuaded because Susie's coworkers had to take on extra work. No other employee could temporarily fill that position, so that's particularly appropriate for those of you, if Susie is in a particularly specialized position. So maybe for school districts here, maybe it's your director of special ed, and it's a tough position to fill. It's very specialized. You can show that there's really no one else that's capable of filling that position. Then you're able to show undue hardship much earlier in the process. Maybe you don't have to wait 2 or 3 months to terminate employment or fill that position on a permanent basis. Now there were issues here where temp employees was not workable. The loan responsibilities were expected to increase, so you can show that through the job, perhaps in the near future, that particular role was entering a busy time, a busy phase, a busy 2, 3, 4 months. You really need them on the job. That, of course, you can show undue hardship, and expecting an increase in business. So again, business conditions might also dictate. So, how does this work in practice? Number one, take every request seriously. Don't get in a situation, don't send out the email that we're going to later regret. Here's Susie, she's asking for yet another extension of time. You can hear it in your voice, right, through that email. And it becomes Exhibit A in our court case, and it doesn't look good for us. So avoid that kind of reaction to requests for leave. Interview at your earliest opportunity. Interview supervisors, people in the know, so that you can identify how that absence is impacting your operations, and then document that. Make sure it's documented that you can show later. What have you done to identify alternatives? Have you thought about accommodations you can provide? What alternatives have been considered and rejected because they won't work? Document that so that you can show the EEOC or a court down the road that you were thinking about this. You were trying to be proactive to get this employee back to work, but for whatever reason, these things didn't apply. Keep in mind reassignment. I've yet to use that word today, right? You haven't heard reassignment from me today. You can have a perfectly compliant process, and one of my clients learned this the hard way, and I had to deliver some bad news to them. It was about a year ago, and they were facing an EEOC charge, and they did an excellent interactive process. Communicated back and forth with the employee, engaged her in a discussion about what she might need to get back to work, and everyone determined that there was nothing that could be provided to help her get back to work, and she remained on a leave of absence for a period of time. But what they didn't consider were there were a handful of other positions for which she was qualified that they could have moved her into. The courts say that reassignment is the accommodation of last resort. So after you've tried everything and nothing works, consider reassignment. Can you move that employee to another position as an accommodation? You don't have to keep their pay the same. You pay them, you provide benefits as if they were in that reassigned position. So you don't need to keep paying them at their regular salary. Under ADA, you can pay them whatever you pay that position that you're transferring them to. But keep in mind, reassignment always has to be a consideration. And then make sure in the end, before you hit that termination button, make sure that you've got documentation on hand that you can defend and you can live with if you're put on that witness stand. If you're forced to explain what you did and why you did it, that you can show through documentation how you did it. That's a properly documented file, and that's frankly an employment attorney's dream, right? To be able to have that to rely on down the road. So I hope that's helpful to you in terms of approaching that kind of situation, because so many of my clients deal with that employee that just continues to remain on leave. Let me finish with just 2 quick points. Here's my blog, FMLAinsights.com. As you'll see in the circled box there, if you want to subscribe to my blog, just pop in your email address, hit go. You'll get an email confirmation for you to click into to confirm that you want to receive updates. I don't spam you. I don't share your email with anyone. I post maybe 3 times a month. So those posts, when I post them, will go right into your inbox, as opposed to you having to constantly visit my website. In front of you, for those of you who are live, I've provided a brochure of what I call my calm service to help you stay calm when it comes to FMLA and ADA issues. It stands for Compliance in Accommodation and Leave Management. It's simply put, it's a monthly flat fee retainer for you to call me up whenever your little heart desires to ask me these kinds of questions and anything else that you're dealing with when it comes to FMLA and ADA. It's meant to be a service where I'm only a phone call away from you or an email away, where you can get some very quick advice on how you handle situations that arise under FMLA and ADA, and so you don't feel like your attorney is dinging the bell every time you're calling in to ask for legal advice. So happy to chat with you more about that if you're interested. And with that, we've reached our Q&A period. I don't know if there are questions either live or online.
There are, and the first one that we'll start with, Jeff, is how do you handle a situation where an employee is wanting to come back to work, but they may be unstable or unsafe for their working environment to return to work?
I guess first I would challenge that to make sure that we have some kind of objective evidence that they're unstable in some way. And that's not a high threshold, but we need to have some reason as to why we may want to keep someone on leave, or maybe we want to send them off for a fitness for duty or an independent medical exam of our own. I've dealt with a situation not too long ago where an employee texted a number of his coworkers essentially the equivalent of a suicide note. Nice knowing you, I'm going to kill myself. They caught him before he did it. He got treatment and was put on leave, but as you might imagine, there were a lot of scared employees upon that employee's return date when he was ready to come back. Is that enough for you to conduct your own fitness for duty exam rather than relying on that one little prescription pad note, right, that you get that Johnny's okay to return to work at this point? In that kind of situation, I think you have enough from an objective standpoint to be concerned enough that you want more medical evidence that he can come back to work safely for both himself and for coworkers. So the threshold isn't high to keep an employee off work or to get a fitness for duty. Not so much under FMLA, but certainly under ADA, we have more latitude to get more medical information from our employees so that we're satisfied they can return to work.
Here's another one that came in. For reassignment, what kind of best practices could you recommend for employers in terms of how exhaustive to make that inquiry and that research, and for how long should they try to pursue a reassignment opportunity?
Yeah, I mean, reassignment it's easier said than done, right? I at least want to show that we've considered it, and I don't think it's enough for us to say, hey, Susie, you know that our open positions are online. Go take a look. I don't think that's enough, and I don't want to rely on that down the road. I'd like my clients to be more proactive, that they've actually, after they've exhausted all accommodation options, and those don't work, let's take another look. What's open right now, or what do we anticipate that's going to be open in the near future? And let's be a bit more proactive. Let's match up Susie's qualifications to what is open, and obviously any medical restrictions that she has. Might there be a position for which she's qualified that she could move into at this point? If that's what I'm expecting of my clients, and to at least be able to show that on one occasion, I think that's going to be enough to satisfy EEOC if they're reviewing, if they're investigating our situation.
Judy collecting other questions. If you have some, keep writing. We're not going to take them off the online because there's too many.
Do we have to offer ADA after leaves have been extended continuously?
Do we have to offer leave? Well, I think I've provided at least my suggested roadmap in situations where leave otherwise would just continue on and on. One approach here is for us to keep saying yes. All right, we'll give you another 4 weeks. We'll give you another 4 weeks, and hope that it resolves itself at some point. But all too often, I find myself in situations where when a client has said that, they're calling me at month 6 and after 12 weeks of leave, and they're helpless. They don't know where this is going to end, and I typically then take them back to this setup that I've just provided you. How can we start laying the groundwork for an exit strategy here? And that is, let's find out what do they need and when can we expect them to return to work? How is it affecting our operations? And at some point, sooner rather than later, if we can, lay it on the line to this employee that this is how it's affecting our operations, and we cannot, without any further information, we cannot extend beyond the next leave, the next set of 4 weeks or 2 weeks or whatever it might be that we are providing now.
If you could repeat the question, I'm just sure everybody's going to be able to hear me. If an employee wants to withdraw an FMLA claim, what is the risk to allow that?
If an employee wants to withdraw an FMLA claim, what's the risk? So I gather that an employee needs leave, but then comes back to you for some reason and says, I don't need leave. This is not uncommon for. I've seen employers do this, and I meant to throw this out earlier when we were talking about that Escriba case where Maria didn't want FMLA to apply. You can have leave of absence forms. Some of you may utilize a leave of absence form that you require your employees to fill out. I'm taking vacation this week, or I have jury duty leave, and you have one form that applies to any absent, and that's perfectly fine. In fact, I recommend it. You may have a section where you ask your employee, are you requesting FMLA leave? That kind of question gives me a bit of a pause because we're assuming in that question that employees understand precisely what FMLA is and what it means and all the conditions that apply. And think about how difficult it is for us in this room or on the webcast. We know FMLA, we know it pretty well. And sometimes we struggle with it as to what applies and what doesn't apply. So imagine our employee who perhaps knows little to nothing about FMLA. When they see that question, do you want FMLA to apply to this absence or something of that sort? They may have no clue what that means. So if you are going to ask that question, I'm not saying that you can't ask that question, but if you're going to ask that question, at a minimum, also have attached to that form an explanation of at least what are the reasons for FMLA leave. When can you take FMLA leave, and lay those out on the back side of that form so that employees know, they have an idea as to what FMLA stands for. Also direct them to your FMLA policy that you have. So, for further information, please see page whatever in the employee handbook that will help explain your rights and responsibilities under the FMLA. So I strongly encourage you to have that. If you are being that direct with your employees with the question of FMLA, that's a roundabout, long-winded answer to that question. But and I'm not sure I even answered it. For that employee that wants to rescind FMLA, I guess I would treat it like I just shared with you. We need to make sure that they understand what FMLA is, and then once they've done that and they've been properly advised of that, if they want to rescind their request, I think that's a pretty defensible position for you to say, okay, we're not going to consider this to be an FMLA request.
This goes back to the social media topic. What states, or how many states, have protection for social media?
How many states have social media laws? That's an unfair question. Let me guess, maybe 10 to 15 have social media laws. Illinois, I think, arguably has the most employee-friendly law. So if you have Illinois operations, you need to be worried about their law. That has a number of restrictions on them to the point where you can't, like I mentioned earlier, you can't even look over the employee's shoulder when he or she knows that you're viewing their Facebook page with them. That's even prohibited under Illinois law. So yeah, I would say right now 10 to 15. Many states have them pending in their state legislatures. They just haven't passed. It was a hot button issue maybe 2 or 3 years ago, and we started seeing states passing these, and it seemingly was going to be it spread like wildfire. It didn't. For whatever reason, it just kind of stopped after the 10 to 15 passed their various laws. So you know, I would certainly work with your employment counsel to know whether it applies in your state, and then what are your obligations.
Great. And I think this will be our last question. What trends are you seeing with the DOL and their opportunities to show up unannounced or request audit information? And how would you advise employers to handle that if they get that knock on their door?
Yeah, that's a really good question. Just to make sure those on the line heard, you know, what trends are we seeing at the DOL? Are they coming on site? Are they coming up? Are they coming unannounced? You know, what are we seeing? What I'm seeing, interestingly enough, and some of you know this, 3, 4 years ago, DOL said, they announced, hey, we're going to come on site a lot more often. Whenever we have the opportunity to come on site, we're going to come on site. So if the employee complains to the DOL about an FMLA issue at their workplace, or the DOL otherwise hears about it, they open up an investigation, and they assign it a number, and it becomes either a small little desk audit or review, or it could blow up into something much larger. And so what DOL said several years back is we're going to come on site a lot more often, so expect that as part of a complaint or our review of your process, FMLA processes. We're likely going to come on site. What we've seen is, particularly over the recent past, there's a heck of a lot more DOL inquiries that we're seeing. So our clients are getting a lot more phone calls. They're getting a lot more letters from the DOL conducting these audits, investigations, if you will, but far fewer than anticipated are actually coming on site. So you may actually see that in the letter that you get from DOL. We're going to come on site. They may tell you that in the letter. We're going to come on site. They may tell you that in the initial phone call or the initial visit. They're pretty much in an FMLA context. They're almost never going to come on site and surprise you. In the wage and hour context, they will. They will come in. The investigator will come into your bar or restaurant or whatever establishment and seek to talk to the bartender or whoever it might be. They're not going to ask for the supervisor or the boss. They're going to talk to the first employee they hit, and they're going to start asking questions. You have the right to tell them to leave. Keep that in mind. You don't have to answer their questions, and in fact, I encourage you to stop it. Let's find a time for us to talk and for the appropriate person to talk with you. And then get their card and wish them a good day, and that you'll be back in touch with them. You have every right to do that, and I encourage you to do that. But the long and short of it is that we're seeing them come on site much less, far fewer times than they threatened that they would. That said, the inquiries by phone and by letter are on the increase. We have a lot of my clients who are getting those kinds of inquiries that turn into these mini investigations that we have to respond to.
Great. Thank you so much, Jeff. As you can see here, we will be providing a roll-up of all the Q&A that we didn't get to today and sending it out to all the participants on the webcast and attending here, as well as a link to a recording of this video, of this webinar. So look for that. Following this webcast, there will be a short survey that you'll see. It will only take you, I promise, less than 2 minutes. Please take the time to do that. With that information, it helps guide us for future opportunities to bring sessions like this to you, as well as get some input from today's session. And so, as Patty said at the beginning of the webinar, this is a hot topic. It is challenging managing ADA and FMLA. I think I would be remiss if I didn't also mention, I think a huge reason for the strong turnout for this webcast has been our presenter, Jeff Nowak. Thank you so much, Jeff, for coming. It was a delight to hear you and have you here in person. And I'm sure you'll look forward to hearing him again. He speaks at a lot of national conferences. If any of you attend the DMEC, the IBI, Jeff is a frequent and very popular presenter at those as well. So thank you, Jeff. I also would understand, I think we all do, how challenging this landscape is. Trying to remain compliant, to be consistent, all while trying to manage your costs in a landscape that is currently changing and will continue to change, both from the state, federal, and municipal leave law levels. So not surprising if everybody feels a little bit overwhelmed. The good news is there are solutions out there to help you with that process and help you with managing your FMLA and ADA to the best of your ability. There are such things as technology solutions, so software can help you with this. There are outsourcing solutions, both through TPAs and insurance companies. So along those lines, if you have questions that aren't answered today, our email for Patty and I are both in there. Please feel free to call us or send us an email. We'd be happy to try to help answer those questions for you. So with that, I think we're about on time. Thank you for attending today, and we look forward to your feedback. So it was a little bit